Good day, Crime Talk aficionados. We have a big show for you today. First, Bryan Kohberger. The court has issued some rulings, some very important rulings, and, well, I'll summarize, denied. But there's a lot of important information in these rulings. We'll have This Day in Legal History and our Dumb Criminal of the Day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out on any of your favorite podcasting apps. Now, as I said in the intro, we have a big show for you today, but before we get there, first, go to crimetalksearch.com, sign up for that background subscription service today. This literally could save your life or somebody else's life. Information is power. When you sign up for that background subscription, you can cancel at any time. But when you have that subscription, you can do one background search or you can do 1,000 searches or 2,000. As long as you have it, you can do whatever you want. And in the report that is literally prepared while you wait, and it's emailed to you and updated as well if new information becomes available, you're going to get information about somebody's social media background. Do they own property? Do they have judgments against them? Do they have a criminal history? All right. Are they on a sex offender registry? All those things you want to know about somebody coming into your life. And maybe he's there already, and maybe you're not getting that warm, fuzzy feeling about them, and you want to check them out to make sure, well, nothing bad happens to you or your family. Go to crimetalksearch.com. You're going to be happy you did. All right, let's go ahead and get to the docket for February 20th, 2025. And first on the docket today, Bryan Kohberger. Some significant rulings that were published late yesterday in the Kohberger matter. First, order on defendant's motion to suppress regarding the arrest warrants, the Pennsylvania warrants, the apartment warrant, and the Idaho warrant search of his person. Order on the defendant's motion to suppress the genetic information. The order for defendant's motion for a Franks hearing, and the order on the defendant's motion to suppress AT&T, Google, USB, Apple, and Amazon searches. That's a lot, ladies and gentlemen. Some of these are rather thick opinions. The Franks hearing opinion is 38 pages in length. The order regarding genetic genealogy search, guess what, is 28 pages in length. The others are a little shorter, but I'm going to hit what I think is going to be the big one. First, the genetic genealogy, and then we will also do as it relates to the motion for a Franks hearing. Those were the important ones. Obviously, genetic genealogy has to do with the DNA that was found at the scene, how they basically found Kohberger as a suspect, and the Franks hearing, that's controlled everything. If the defense had won that motion, basically there would be no case against Bryan Kohberger, and now basically everything is going to come in. So a lot of this is really important, and I could simply say, well, they were all denied and move on and say Bryan Kohberger has had a really bad day, and he may have some really bad days coming up as it relates to a trial. But in this particular case, I think it's worth going through some of these. Now, I'll try to hit the high points, skip over some of the case citations that the court goes through. But I think it's important because we do learn some new information and facts throughout the case. So let's hit it first. The order on defendant's motion to suppress the genetic information. So introduction. Now, this is the judge's order. Like I said, this is, if you include the certificate of mailing, it is 29 pages long. Stephen Hippler wrote it. Here we go. And this is in the case of State of Idaho versus Bryan C. Kohberger, defendant. Defendant is charged with 1 count of burglary and 4 counts of murder in the first degree. It is alleged that the defendant entered a residence at 1122 King Road in Moscow, Idaho in the early morning hours of November 13th, 2022, and stabbed Madison Mogan, Kaylee Gonzalez, Ethan Chapin, and Zaina Kernodle with a knife. Left at the crime scene was a knife sheath from which single source male DNA was extracted. Using forensic investigative genetic genealogy, IgG, law enforcement is able to identify the defendant as a possible suspect weeks after the crime occurred. Subsequently, law enforcement conducted a trash pull from the defendant's family's residence and obtained DNA tying defendant to the DNA found on the knife sheath. The defendant was subsequently arrested pursuant to a warrant and charged in this matter. The defendant asserts law enforcement violated his constitutional rights by failing to secure a warrant before conducting the IgG and trash pull. He seeks to suppress all evidence obtained through these searches, as well as evidence obtained through subsequent warrants as fruit of the poisonous tree. The state disputes that defendant's constitutional rights were violated. A suppression hearing was held on January 23, 2025, during which the court received testimony from members of law enforcement and experts in IgG, each of whom the court found to be credible and reliable. Following argument, the court took the matter under advisement. The court finds defendant has failed to demonstrate his constitutional rights were contravened by the IgG and the trash pull, and therefore suppression is not warranted. Now, the standard of review of a motion to suppress is bifurcated. The power to assess the credibility of witnesses, resolve factual conflicts, weigh evidence, and draw factual inferences is vested in the trial court. A trial court's ruling on a motion to suppress evidence combines the issue of law and fact, and the trial court's factual findings will not be overturned unless they are clearly erroneous. When a decision on a motion to suppress is challenged, the application of constitutional principles to the facts found will be freely reviewed. Finding of fact. On November 13th, 2022, law enforcement found the bodies of Madison Mogen, Kaylee Gonzalez, Zeno Kernodle, and Ethan Chapin inside the residence located at 1122 King Road in Moscow, Idaho. All four victims died from apparent knife wounds. A K-bar knife sheath was found on a bed next to the bodies of Miss Mogen and Miss Gonzalez. Law enforcement seized the knife sheath and swabbed around the button of the sheath for DNA. A sample of the DNA was identified as Q1.1, was extracted from the swab by the Idaho State Forensic Lab and subsequently tested using the standard DNA STR short tandem repeat methods. The STR profile developed revealed that the DNA came from a single source male profile. Law enforcement uploaded the DNA profile to the CODIS database, but it resulted in no hits to known offenders. Subsequently, law enforcement made the decision to pursue forensic investigative genetic genealogy (IgG) testing on Q1.1. Such testing begins with the generation of a large amount of raw sequencing data from the DNA sample, which is then organized into SNP, or single nucleotide polymorphisms. Using bioinformatics software, the SNPs associated with ancestry and genealogy can then be pulled out of raw data and organized into an SMP profile that can in turn be uploaded to commercial genetic genealogy databases to search for a genetic match. Depending on the strength of the match, law enforcement can start building a family tree to identify potential genetic relatives of the uploaded SNP profile. These genetic genealogy databases are hosted by private companies and populated by hundreds of thousands of members of the public who voluntarily submit their own DNA and publicly share personal information to allow the database to better match them with potential genetic relatives. Notably, at all relevant times, only two commercial genetic genealogy databases permitted searches by law enforcement: Family Tree DNA and GED Match Pro. The databases MyHeritage and GED Match purported to disallow such searches. The IgG process essentially attempts to ascertain, identify through genetic associations, unlike STR profiles, which can only reveal whether a person is genetically male or genetically female. The SNP, in their raw form, have the ability to reveal a trove of personal information, including sensitive health information, such as whether the person has traits indicating an increased risk for cancer or Alzheimer's. However, IgG does not target these particular SNPs because, according to the defense expert, Daniel Hellwig, they are neither relevant nor probative nor appropriate to the identification process. In fact, gleaning medical information from NSPs is not possible for a layperson to do and would take a forensic scientist like Mr. Hellwig a lot of research. The IgG was first performed by Ortham Labs, a company which the Idaho Department of Purchasing has an existing contract for such work. Ortham was asked to develop the SMP profile from Q1.1, upload it to those public genealogy databases, permitting law enforcement entry, and submit a preliminary report of the findings. Ortham was not asked to ascertain medical information associated with Q1.1, nor is there any evidence it tested for such. Law enforcement did not obtain a warrant for Ortham's work. The Idaho State Police delivered Q1.1 to Ortham on November 22, 2022. Ortham developed an SNP profile from Q1.1 and searched family tree DNA and GED Match Pro. This work revealed 4 brothers of interest, all of whom were low matches to Q1.1. To further its family tree building, Ortham asked the Idaho State Police to contact one of the identified brothers to provide a DNA sample to upload into their databases. Despite Idaho State's police request, the contacted brother declined to provide a sample. On December 10, 2022, members of law enforcement, including the FBI, had a meeting to discuss Ortham's work. As a result, a decision was made to turn the IGG work over to the FBI. That same day, Ortham was instructed to stop work and turn over its SNP profile and search results to the Idaho State Police. Ortham did so, along with a preliminary report of its findings. The preliminary report did not contain any medical information associated with the SNP profile. The Idaho State Police then turned the information over to the FBI, which was able to use Ortham's profile to develop a significantly larger SNP profile. The FBI uploaded the larger SMP profile to multiple genetic genealogy databases, including GED Match and MyHeritage, which purport to disallow law enforcement searches. At the time, the FBI had an interim policy issued by the United States Department of Justice related to IGG analysis and searches by its agencies. On the one hand, the interim policy required that investigative agencies conduct IGG searches in genetic genealogy databases, permitting law enforcement use. However, on the other hand, the interim policy also stated it was intended only as internal guidance and did not impose any legal restrictions on investigative agencies, noting the interim policy is not intended to, does not, and may not be relied upon to create any substantive or procedural rights or benefits enforceable at law or in equity by any party against the United States or its department, agencies, entities, officers, employees, agents, or any other person in any matter, civil or criminal. The interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. From the information it acquired through the database search, the FBI was able to build a family tree and arrive at a potential match. On December 19th, 2022, the FBI provided defendant's name to Idaho law enforcement as a possible source of DNA. The FBI instructed that the identification of defendants as a person of interest was to be considered solely as a, quote, tip. No warrant was obtained for the FBI work, and subsequent warrant applications did not include the IGG revolt to inform probable cause. As the investigation ensued, law enforcement discovered that defendant had driven from Pullman, Washington to his parents' home in a gated community in Monroe County, Pennsylvania. At the time, Monroe County's municipal waste ordinance required homeowners to dispose of their garbage by placing it out for collection and delivering it directly to a licensed waste hauler. Only an authorized trash collector could collect garbage left out for collection. Law enforcement decided to conduct a warrantless trash pull from the Kohberger residence. Arrangements were made with the local trash collector to isolate and turn over the Kohberger's garbage to law enforcement for testing. Articles of trash were retrieved and sent to the Idaho State Police Forensic Lab to conduct standard DNA testing. A DNA profile developed from one article of trash was determined to be from the biological father of the source of Q1.1. Another article of trash revealed a mixture of male and female DNA. And according to the defendant's expert, Gary Schulter, PhD, the male DNA from the mixture was consistent with Q1.1 profile affidavit of G. Schutler, dated December 19, 2024. Importantly, defendant has not claimed ownership or knowledge of the knife sheath from which Q1.1 was taken. After obtaining a search warrant, law enforcement collected DNA from a buccal swab obtained from the defendant. A traditional STR DNA comparison was done between the Q1.1 profile and the defendant's DNA. The comparison showed a statistical match. Specifically, the defendant was 5.37 octillion times more likely to be the source of the Q1.1 profile than an unrelated individual randomly selected from the general population. Defendant was subsequently charged in this case. Conclusions of law. The Fourth Amendment to the United States Constitution protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure, citing the Fourth Amendment to the United States Constitution. In seeking suppression of evidence based on a warrantless search, a defendant bears the evidentiary burden to show that he had a legitimate expectation of privacy in the place to be searched. This involves a two-part inquiry. 1. Did the defendant have a subjective expectation of privacy in the object of the challenged search? And 2, is society willing to recognize that expectation as reasonable? The former is a question of fact, the latter a question of law. When a defendant makes such a showing, the burden will shift to the state to show an exception to the warrant requirement exists or that this search was reasonable under the circumstances. Here, defendant challenges 3 allegedly unlawful DNA-related searches. 1, the development of the SNP profile, Q1.1. 2, the trash pull from Kohberger's residence and subsequent DNA testing thereon. And 3, the search of the commercial genetic databases using the SNP profile. He seeks to suppress not only the genetic information obtained by law enforcement, but all other evidence obtained as a result of the alleged illegality. In response, the state argues the defendant has not met its threshold burden of demonstrating that a constitutional violation occurred with regard to any of these 3 searches. The state is correct. Defendant has not established a Fourth Amendment violation with regard to the development of the SMP profile. Defendant first asserts that the extraction and testing of DNA from the sheath to develop the SNP profile constituted an unreasonable search mandating suppression. Noting recent advances that have been made, DNA capable of revealing prolific and sensitive information, as well as the fact that humans continually shed DNA into the environment, defendant asks this court to find that he had a reasonable expectation of privacy in his DNA, the testing of which through SNP methods required a warrant despite the fact that law enforcement was lawfully in possession of the object containing the DNA, the sheath. He further persists that this privacy interest is not subject to the doctrine of abandonment because the shedding of DNA into the environment is not a voluntary or knowing act. The state denies that the testing of the DNA from the sheath was a search, pointing out the DNA was lawfully seized evidence from the scene of the crime. The state further contends that the defendant has not demonstrated he had a reasonable expectation of privacy in this DNA because he abandoned it or because he was not shown the existence of a reasonable privacy interest society is willing to recognize. This is a matter of first impression in Idaho. However, applying well-settled principles of Fourth Amendment law, the court finds no constitutional violation. First, defendant abandoned any privacy interest in his DNA by disclaiming knowledge or ownership of the sheath from which the DNA was extracted. Second, even if no such abandonment occurred, there is no reasonable expectation of privacy in DNA found at a crime scene, which is subsequently analyzed to identify an unknown suspect. Next paragraph. 1. Defendant cannot establish a subsection expectation of privacy in the DNA found on the sheath due to abandonment. It is well settled that a person who voluntarily abandons property prior to a search cannot be said to possess the requisite privacy interest under the Fourth Amendment. When one abandons property, there can be nothing unlawful in the government's appropriation of such abandoned property. In the Fourth Amendment context, abandonment occurs through words, acts, and other objective facts indicating that the defendant voluntarily discarded, left behind, or otherwise relinquished his or her interest in her property. Disclaiming ownership or knowledge of an item constitutes abandonment. State v. Melling. In Melling, for example, officers reported to the defendant's house after reports of a fight. While officers were speaking to the defendant, his girlfriend gave officers a lockbox that she said belonged to the defendant. The defendant told the officers he had never seen the box before, had no idea who it belonged to, and that nothing in the box was his, and that he did not know what was inside of it. The court held that by disclaiming ownership of the lockbox and its contents, the defendant abandoned any privacy interest therein. Moreover, a person need not specifically disclaim knowledge or ownership of the contents of a container to result in abandonment thereof. It is sufficient to disclaim knowledge of ownership of the container itself. There's no dispute here that the defendant has not claimed any knowledge or ownership of the sheath, thus resulting in its abandonment. Defendant concedes as much, but argues that abandonment of any privacy interest in the sheath did not result in the abandonment of the DNA found on the sheath. He contends that unlike the voluntary act of leaving the sheath, leaving DNA on the sheath is not voluntary because a person has no way to know that their DNA has been left behind. DNA, he points out, is shed everywhere. Humans have no ability to keep their biological material from the environment. Consequently, he reasons a finding that the DNA on the sheath was abandoned would mean that a person voluntarily gives up privacy in their entire genetic makeup every time they interact in the public. In support of this argument, the defendant relies exclusively on a concurring opinion in State v. Carbo, which was factually similar to this case. In Carbo, the evidence at issue was semen deposited inside the deceased crime victim and skin scrapings from underneath her fingernails. In an attempt to identify a suspect, law enforcement contracted with a lab to conduct a genetic analysis of the DNA extracted from the evidence. Like here, the lab created an SMP profile from the DNA and utilized commercial genealogical databases to determine a potential source. It also generated a report that provided information about the suspect's physical traits and ancestral origin. The information ultimately led law enforcement to the defendant. Law enforcement then created a DNA profile from trash discarded by the defendant, which matched the DNA profile from the crime scene. Subsequently, the defendant provided a voluntary DNA sample, which matched the profile from the crime scene and the garbage. The defendant moved to suppress evidence that his genetic information left behind at the crime scene. He argued, as defendant does here, that although he may have abandoned his privacy interest in his semen and skin cells, it did not equate to an abandonment of the vast troves of genetic information that biological material contained. Making short work of this argument, the Minnesota Supreme Court found that by voluntarily leaving his semen and skin at the crime scene, he abandoned any subjective privacy interest in his genetic information contained therein. In the concurring opinion relied upon by defendant, one justice disagreed with the majority on the issue because, given the sensitive genetic information revealed by the SNP testing, he would have required a warrant before allowing such testing. He further opined that the concept of abandonment, which requires voluntariness, is an ill fit for genetic information because it's virtually impossible for humans to prevent leaving personal genetic information everywhere they go. To this end, he compared DNA to the cell phone site location information, CSLI, at issue in Carpenter v. United States, where the United States Supreme Court reasoned that CSLI is not voluntarily exposed, given that virtually any activity on a phone, which is essential to participate in modern life, will leave a trail of location data. While there are safeguards to prevent the dissemination of CSLI, i.e. turning off the phone, he observed that there are no similar safeguards for DNA, thus rendering the case against abandonment all the more clear. When we venture into the public spaces, we simply cannot help but shed our DNA. The majority, however, pointed out that the inquiry as to whether the defendant abandoned his subjective privacy interest looks to the specific actions. Viewed this way, the majority found the dissenting justice's logic inapt, given the defendant's DNA was not collected from a shed cell or flake of dandruff, nor was it a mere consequence of the defendant's venturing into the public sphere. It was collected from semen he voluntarily left inside the victim and skin cells he voluntarily left under her fingernails. Defendants argues that the justice's case against abandonment is particularly appropriate here. Defendant argues the biological material left on the sheath was not blood or semen or some bodily fluid that the Carbo court found could be voluntarily left behind. Instead, he argues it was more likely shed cells, which humans cannot help but discard. However, as the state points out, there is nothing that distinguishes semen voluntarily left at a crime scene from the sheath. Both were abandoned vehicles carrying DNA. Stated another way, the semen in Carbo and the sheath here were both containers of DNA. As discussed, disclaiming ownership or knowledge of a container results in abandonment of any privacy interest in the contents. Thus, by effectively disclaiming knowledge or ownership of the sheath, defendant necessarily abandons any privacy interest in the DNA it contains. Indeed, Carbo is not an anomaly in finding abandonment. Courts uniformly hold that a person abandons any privacy interest in their DNA for purposes of the Fourth Amendment when they abandon property that contains their DNA. In State v. Burns, for example, law enforcement extracted DNA from a bloodstained dress of a victim and created a genetic profile, which was run through the genetic genealogy. The defendant was identified as a suspect through this process. Officers then followed him to a restaurant and collected a straw the suspect deposited in the trash. Testing of the DNA on the straw indicated that the DNA extracted from the dress could be the defendant's. A subsequent test confirmed it. The defendant did not move to suppress the extraction and analysis of his DNA from the bloodstained dress, but he did unsuccessfully seek suppression of the DNA extracted from the straw. On appeal, the court had little difficulty finding that any privacy interest he had in his DNA profile developed from the straw was abandoned. First, by failing to make any effort to preserve the straw as private, he relinquished any subjective privacy interest therein. Second, even if he retained a subjective privacy interest, it was not one society would recognize as reasonable, considering he voluntarily left the straw behind in the restaurant. Further, the court rejected that the defendant's attempt to distinguish the DNA on the straw from the straw itself, finding no practical difference between the two. By abandoning the straw, he also abandoned the DNA on the straw. The Burns court additionally rejected the argument defendant makes here. The DNA cannot be voluntarily abandoned due to involuntary shedding. In doing so, the court aptly recognized DNA shed to fingerprints, something individuals also unconsciously and continually shed. First, the court observed all the different ways the person can shed DNA is irrelevant to Fourth Amendment purposes. What is relevant is the DNA left on the particular item the defendant abandoned, i.e. straw or here the sheath. Second, the court noted the DNA shed is no different than latent fingerprints. Like DNA, latent fingerprints are left typically without volition everywhere humans go. Like DNA, they are powerful means of individual identification, not visible to the human eye, and must be developed through the use of specialized technology. The court concluded that because the testing of the latent fingerprints does not raise Fourth Amendment concerns, neither should DNA collected and tested from an abandoned item. The court finds the analysis in Burns compelling and consistent with Fourth Amendment law. The court recognizes that a distinction can be drawn given the fact that in Burns, there was no question that the defendant abandoned the straw, and here, defendant argues it cannot be conclusively stated that he abandoned the sheath. However, as the state notes, the distinction does not preclude a finding of abandonment for two reasons. First, as discussed, abandonment does not occur solely by discarding an item. It also occurs by disclaiming ownership or knowledge or otherwise relinquishing an interest in the property. By not claiming ownership of the sheath or any knowledge to how his DNA arrived on the sheath, defendant abandoned any privacy interest in the DNA. Second, the fact that a person does not knowingly expose his DNA to the public does not contravene a finding of abandonment. Like DNA, fingerprints and bodily fluids are left unknowingly on surfaces on public places merely as a consequence of venturing into the public sphere, as noted in Burns. This does not raise constitutional concerns. What matters is what the material was left in the public domain. Applying this rationale, the Maryland Supreme Court concluded that the defendant abandoned any privacy interest he had in his shed DNA collected from a chair in which he had been sitting. In doing so, the court rejected the notion that abandonment requires an explicitly voluntarily knowingly act, noting the fact that one has knowingly exposed to the public certain evidence does not by itself demonstrate a reasonable expectation in that evidence. Now, while Katz says it is no search to discover what one knowingly exposes, it does not declare the exact reverse of this proposition. That is, the Supreme Court did not say that discovery of what not knowing exposed is inevitably a search. Likewise here, at some point, defendant apparently interacted with the sheath to a sufficient enough degree that left his DNA thereon. Whether he knew he left his DNA behind is of no consequence. It is only relevant that he exposed his DNA to the public by leaving it on the sheath, thus forfeiting any reasonable expectation of privacy in the DNA left behind. Even if not abandoned, the defendant has not established a subjective privacy interest in his DNA is objectively reasonable. A Fourth Amendment search occurs when the government seeks to gain information by infringing upon a person's reasonable expectation of privacy. An expectation of privacy is objectively reasonable when it is legitimate, justifiable, and one that society should both recognize and protect. It is true that DNA testing, particularly NSP testing, can unlock a wealth of intensely private information about an individual, including family relationships, ancestry, genetic disorders, and the propensity for health-related risks. Victoria Rome, Crime, DNA, and Family Protecting Genetic Privacy in the World of 23andMe. Such highly private information is already protected under the law in other contexts, including the Idaho through the Genetic Testing Privacy Act, which prohibits genetic discrimination in employment. Given the privacy interests implicated by DNA testing, defendant argues that DNA, even lawfully in possession of law enforcement, cannot be tested absent probable cause and a warrant. In defendant's view, the breadth of information SMP testing can reveal is analogous to the CSLI at issue in Carpenter, where the United States Supreme Court held that a person maintains a legitimate expectation of privacy in the record of his physical movements as captured through the CSLI data maintained by the person's wireless carrier. The Carpenter Court reasoned that those detailed encyclopedic records, which provide an all-encompassing record of the defendant's location over a course of 127 consecutive days, can give law enforcement an intimate window into a person's life, revealing not only his particular movements, but through them his familial, political, professional, religious, and sexual associations. These location records hold for many Americans the privacy of life. Defendant also relies on Riley, where the United States Supreme Court held that police may not search digital information from a cell phone seized pursuant to the search incident to arrest exception to the warrant requirement. The court observed that unlike physical objects, digital data on a cell phone does not implicate the same governmental interest justifying searches incident to arrest. Further, the court found that the extent of the personal information digital data would reveal about a person's implicated significant privacy interests, noting that while an arrestee has diminished privacy interest, it does not mean that an arrestee has no Fourth Amendment protections. By analogy to Riley, defendant contends that the law enforcement should be required to obtain a search warrant to analyze the DNA from the sheath, despite being in lawful possession whereof. With regard to the SNP testing of DNA in particular, defendant relies upon Skinner v. Railroad Labor Relations Executive Association, where the United States Supreme Court held that the collection and subsequent testing of an employee's legally obtained urine constitutes a Fourth Amendment search. The court observed that while a physical intrusion into an employee's body to collect the urine is an obvious infringement on the employee's reasonable expectation of privacy, the subsequent chemical analysis of the urine sample to obtain the physiological data about the employee is a further invasion of the employee's privacy interest, given that such testing can reveal a host of private medical facts about an employee, including whether he is epileptic, pregnant, or diabetic. Based on Carpenter, Riley, and Skinner, defendant contends that because SNP testing of DNA is even more revealing than CLSI data or urine testing, it should be allowed only upon a warrant, regardless of whether the DNA was lawfully obtained. Defendant argues that this is precisely what the Fourth Circuit did in United States v. Davis when it held that the extraction of the DNA and the creation of a DNA profile result is sufficiently separate invasion of privacy that such acts must be considered as a separate search under the Fourth Amendment, even when there is no issue concerning the collection of the DNA sample. At issue in Davis was DNA extracted from the defendant's clothing, which had been lawfully seized 4 years earlier when the defendant was a crime victim in an unrelated case. Relying on Skinner, the court reasoned that the extraction and analysis was a search because the analysis of biological samples, such as those derived from blood, urine, or other bodily fluids, can reveal physiological data and a host of private medical facts. Such analysis may intrude upon expectations of privacy. However, these cases lend no support to the defendant when applied to the specific circumstances presented here for 3 reasons. 1, there is no reasonable expectation of privacy in identity. Defendant has not shown his DNA was tested for anything other than identifying purposes, and even if the DNA analysis revealed sensitive personal details, there's no reasonable expectation of privacy in a crime scene DNA. I'm going to jump to the conclusion of this part where it says, here the defendant provided no evidence that the SNP profile developed from Q1.1 through the IgG revealed any genetic predispositions or physiological or medical conditions. As Mr. Helwig testified, the SNP that carry such sensitive information are not targeted or revealed in IgG because they are neither relevant nor probative nor appropriate to the identification process, which is the goal of IgG. Rather, IgG only implicates those SNPs associated with ancestry and genealogy in order to determine genetic associations, build a family tree, and identify potential genetic relatives of the uploaded SNP profile. It is simply an identification tool. In this regard, Carpenter is unavailing authority and has been found by other courts addressing the issue of privacy interests in DNA. The CLSI in Carpenter was not used as an identification tool. It was used as a comprehensive surveillance tool after the suspected had already been identified. This is not the type of information the DNA provides in this case. Law enforcement had extracted and analyzed the DNA of an unknown suspect solely for identification purposes, and it provided no information as to the location of a known person and does not begin to approach the surveillance described in Carpenter. Next, moving on to the trash. Defendant has not established a Fourth Amendment violation with regard to the trash pull and the testing of DNA therefrom. The defendant next asserts that the law enforcement trash pull from his parents' Pennsylvania residence and subsequent DNA testing thereon constituted warrantless and unreasonable searches mandating suppression. He argues he had a reasonable expectation of privacy in his parents' garbage that was violated when law enforcement arranged for a trash pull. The privacy interest, according to the defendant, is predicated not only on Monroe County's municipal ordinance prohibiting anyone other than a garbage collector from collecting the Kohberger's family curbside trash, but also from the fact that the Kohberger's residence is a gated neighborhood and the garbage cans were on the driveway as opposed to the public area. While the defendant acknowledges binding precedence holds otherwise, he asserts it is time to rethink these decisions and find a reasonable expectation of privacy exists. If not under the Fourth Amendment, then under the increased protection afforded by Article 1, Section 17 of the Idaho Constitution. Alternatively, he argues that even if the trash pull was lawful, the testing of the DNA found on the items of trash was not under Skinner and Davis, which he cites previously. However, after defendant filed his motion, the Idaho Supreme Court reaffirmed its holding in Donato and rejected the very argument asserted by the defendants here, that the local waste management ordinance can create a reasonable expectation of privacy. An objective expectation of privacy is not created simply by an ordinance aimed at maintaining society's interest in sanitation dictates how trash is to be collected. As for the subsequent DNA testing of the discarded items relevant here is the abandonment theory. The court is bound by the decisions of the Idaho Supreme Court. There are no facts presented here that meaningfully distinguish this case from Donato or Polizzi. That the garbage cans may have been placed in the Kohberger's driveway for collection as opposed to a public road, and that Kohberger's neighbors was gated are legally irrelevant factors given the garbage was placed for the purpose of having it collected by another. Therefore, the trash pull did not contravene defendant's Fourth Amendment rights. Defendant cannot establish that the search of the genetic genealogy databases implicate Fourth Amendment rights. Defendant's final argument is that law enforcement warrantless search of the genetic genealogy databases violated his right to privacy in his relatives' genetic information. Observing that this issue has not been addressed by the United States Supreme Court or Idaho appellate courts, he asks the court to recognize as a matter of first impression that he has a reasonable expectation of privacy in the genetics he shares with his relatives, and further finds that such privacy was not undermined when his relatives uploaded their genetic information to the commercial genetic genealogy databases. Alternatively, he claims the FBI searches of MyHeritage and GD Match was unlawful because those databases were off limits to law enforcement, both under the interim policy and those databases' own terms. The state responds the defendant has failed to demonstrate a reasonable expectation of privacy either in any of the commercial genetic genealogy databases or in his relative's DNA. Even if the defendant could assert a privacy interest in the latter, the state contends that such interest was lost when such relatives shared the DNA with the public by uploading it to the database. Moreover, it argues that any violation by law enforcement of the term of service of these databases or its own internal policies does not implicate the Fourth Amendment. The court has already determined that the defendant has failed to show a legitimate privacy interest in the challenges developed of the SNP profile from Q1.1, the defendant does not have a reasonable expectation of privacy in the SNP profile. There is no basis to find an expectation of privacy in those portions of this SNP profile he shares with relatives. However, to the extent the court's prior conclusions does not dispose of the issue, defendants' assertions lack merit because, one, the defendant has not shown a reasonable expectation of privacy in any commercial genetic genealogy database or in his relative's DNA, and any alleged violation by law enforcement of its own policy. Then it goes on, the defendant cannot demonstrate a reasonable expectation of privacy in common segments of DNA a relative has uploaded to the public. Therefore, cutting to the chase, based upon the foregoing, the court denies the motion to suppress genetic information. I know that was a lot, ladies and gentlemen, but it's interesting. The judge notes that, hey, Bryan Kohberger, I want an expectation of privacy to my DNA on the knife sheath, but I'm not claiming ownership of the knife sheath because they're going to say, I have no idea how my DNA got there. I'm constantly shedding DNA. That could have got there by any way. Could have been transferred by the real killer, that type of thing. But as I've said before, the reason why the defense filed these motions, and these were long shots from the beginning, the case law in other jurisdictions goes against the defense analysis in Idaho. And the court was not going to say, I'm going to suddenly create that. This was done, and I've said this before, these motions were filed for appellate purposes. These were if there is a loss for Bryan Kohberger. So the gist of it is everything got denied. All right. Search warrants, genetic genealogy, no Frank's hearing, nothing. The defense got nothing. All of the search warrants from AT&T, Google, USB, Apple, and Amazon denied. I'll take a closer look at all this and summarize these for tomorrow. But the IGG was the crux of the case. That's what this case came down upon. And other people say, oh, it doesn't matter. DNA's not there. I'm telling you, I've tried cases with DNA. And unless you can explain how your DNA got on that little knife sheath underneath a victim at a quadruple homicide, you've got some explaining to do, ladies and gentlemen. And the court goes into some more details as what was obtained, but not a lot in these other issues, in these other orders. So we'll take a closer look at them. Next, this day in legal history. In 1792, on February 20th, the establishment of the United States Post Office Department. That's right. President George Washington signed the Postal Service Act, creating the United States Post Office. And obviously this act laid the foundation for the national postal system across the nation. On this day, February 20th, 1809, the United States Supreme Court issued the decision in United States v. Peters. That, led by Chief Justice John Marshall, ruled the United States in United States v. Peters that federal courts have supremacy over state courts. This decision reinforced the authority of the federal judiciary, ensuring that state legislatures could not annul judgments of federal courts. Supremacy clause, ladies and gentlemen. On this date, 1920, founding of the ACLU, the American Civil Liberties Union. It was established with the mission to defend and preserve individual rights and liberties guaranteed by the Constitution. Like I said, ladies and gentlemen, the Constitution matters. On this day in 1946, signing of the Employment Act. That's right, President Harry Truman signed the Employment Act of 1946, aiming to promote maximum employment production and purchasing power. The act signifies the federal government's commitment to economic stability and growth. And finally, our dumb criminal of the day. Probably one of the dumbest criminals we've had in a long time. He violates every rule, commit crime, and then live stream the crime scene. So one of North Carolina's dumbest criminals, John Sutton Jr., apparently thought he was invincible, or maybe just stupid, when he allegedly decided to sell weed right outside the Warren County Sheriff's Office. Now, Mr. Sutton was recently taken into custody after allegedly setting up shop right outside the Warren County Sheriff's Office to allegedly sell weed. The drug dealer even reportedly live streamed the deals on Facebook. Well, this incident took place on February 13th, the day before Valentine's Day. And according to police, a plainclothes officer approached Mr. Sutton in the parking lot after hours where he was reportedly advertising his product. The undercover officer then made a purchase, and Mr. Sutton sold the undercover officer, marijuana. Mr. Warren was subsequently taken into custody, charged with selling marijuana and possession with intent to sell and deliver. Mr. Sutton bonded out after posting a $30,000 bond. Dumb, right in front of the police sheriff's office. Not smart at all. All right, ladies and gentlemen, that's all we have for today. Thanks for watching. We'll see you next time. Remember, the Constitution matters.